Guys, let's talk about attorney-client privilege. You've all heard about it, but what does it mean? Can your lawyer tell the court what you said in private, even if you've confessed? Let's show how it works. So in every state and in the federal government rules of evidence, there is something called attorney-client privilege. So if you tell your lawyer something in confidence about past conduct, then it's ironclad. There is no way that attorney or that attorney's staff, as long as they're working under the direction of the attorney, can tell anyone, can leak this information, can make sure that that privilege is not undone. The client himself or herself has the privilege, and that's the only person that can waive it. Now, let's say that a client comes in and talks about a future crime and then says, I'm going to go out and shoot someone tonight. Well, at that point, the privilege doesn't apply, and then I have an ethical duty to make sure that that doesn't happen. So that's essentially, in a nutshell, the differences between when it sticks and when attorney-client privilege applies and when it doesn't. There are obviously nuances to that case, but the main thing is there is a firm protection from me disclosing any information that my client tells me. So what does that mean? Tell your lawyer everything. That's the point. The defense is built around all of the evidence, and the more of the story that they have, the better. So you're not just hiring a defense attorney, you're hiring confidentiality, and it's backed by the law. Remember that. It's extremely important. Again, every law firm has that privilege. Every lawyer has that privilege, as long as it's asserted in a proper way, and there's no third party that could have heard or was involved in that conversation. Have any questions about that or you need help? Give us a call at the Bradley Law Firm. Thank you.